Hi, I'm Brian Stetton. I'm the Policy Director of the Treatment Advocacy Center, and I'm here today with the legendary Judge Oscar Kazen, Associate Probate Judge in Bexar County, Texas, a county of about 2 million people, I think, that is really doing the most with AOT of all the counties in Texas. And Judge Kazen, I'd like to start by just asking you to give us some sense of how the program began there. What were the origins of it? Who was the sort of visionary behind getting it off the ground, and what sort of went into the initial ramp up?
For many years in Bexar County, we had a visionary judge, Judge Polly Jackson Spencer. And in Texas, we have always had an involuntary outpatient commitment statute. And it originally had a very humble beginning. She got together with Leon Evans from the Center for Healthcare Services and decided to hire one court officer that would track down and ensure that people who had been placed on a treatment plan were successfully completing treatment. Initially, she would execute an order, and then that would be the last she would see of them. And this case manager, more like an ACT team member, would make sure that they were doing court orders or following along with treatment. So it had very humble, very automated, or they were beginning. When it originally began, and since we had one caseworker who was autonomous and making sure that persons were complying with treatment.
Yeah. Can I just ask you, what year was it that it began?
I don't know, actually. It would have been about 12 or 13 years ago.
Okay.
12 years ago. When she began in that mechanism.
Right.
About 12 years ago, 10, 12 years ago. So she began to notice, and we began to notice in the county, that the truly treatment-resistant individuals were still not complying with treatment. They didn't see a consequence to not adhering to a court order, especially if it was just a piece of paper. Along the way, about 10 years ago, Judge Spencer appointed me, and the county appointed me as the associate probate judge, tasked primarily with mental health. I had already been the treatment court judge for the Bexar County drug courts, one of the Bexar County drug courts. Okay. In fact, that was one of the very first two certified treatment court or drug court judges. When I was appointed to this position, because I had been a treatment court judge from the drug courts, Judge Spencer gave me leeway to apply the model of treatment court in the drug courts to the AOT statute. And that's when it truly came to fruition. A true outpatient, at least here, a true outpatient court, that is a court that executes an order for treatment, but also monitors and ensures that not only the individual, but the provider adhere to the treatment plan.
Okay. So you took it over at that point, and have been doing it ever since.
Correct. We began small, about 9 to 10 years ago. We began with one or two caseworkers. We now have 5 caseworkers, a transportation officer, a court liaison officer that coordinates the paperwork and the docket. In essence, we took what was an existing ACT team and coordinated such that they would work hand in hand with the court order and with the court. We further added some of the principles from other treatment courts and drug courts, in that the patients are and do meet with the judge once a week, and the judge meets with the team almost every day or once a week to see how these patients are doing.
Right. So that's an approach. You had mentioned that you had a background with drug treatment courts, so it sounds like that's sort of an approach that you sort of brought with you from having worked in that model.
Correct. So yeah. It's not to say you have to. I mean, you can certainly. That's the beauty of an outpatient treatment court. You can certainly build it in whatever model works for each jurisdiction. Mm-hmm. It just happens that I believe that when a judge executes an order and the judge becomes the face of that treatment order, for treatment-resistant individuals, it is the difference between wanting to comply and feeling they have to comply.
Right.
And it's called that black robe effect. If they know that there's a responsibility that's placed on them and there's a court that's monitoring and watching it, there's more of a tendency for the patient to do what they feel they have to do. And they go from feeling they have to do it to knowing they want to do it.
Right. As they sort of graduate and as you get towards the end of the period of the order, you're hoping not to have to renew the order because you have an individual who's ready to fly on their own.
Absolutely.
Yeah.
And truthfully, we very rarely do more than 2 90-day orders. Even amongst the most treatment resistant, we tend to find that within 6 months, that we do in Texas, we can do up to a year of outpatient order, but we do 90 days at a time.
Right.
And as a practical matter, we do 90 days. And we find that by the second term, all the issues that precluded them from successfully completing on their own are resolved. Health, medication management, peer support, all become the habit. We resolve issues because they're on a court order, and we're working closely with the provider. We resolve issues such as housing, income, resources, benefits packaging, and we take care of those issues that for the truly treatment resistant are mountains. For us, they're molehills. We don't let the system fail them. If they're going to fail at all, it's because they failed the system. I'm not going to allow the system to fail them.
Right. I would imagine that a lot of judges who are watching this are a little bit overwhelmed by hearing you describe how much goes into making sure people get a decent package of services, because from the point of view of, I think, a lot of judges, that's not really a judicial role. It's not really something they're that enthusiastic to step into. How do you sort of work with the staff to keep people's roles in place such that you, are, as a judge, you're not having to involve yourself in too much depth with the nuts and bolts of making sure a person gets this package of services?
In all honesty, if the judge has ever had any experience with a criminal docket, and that's not to say that these people are on probation,
right?
But the level of effort, or the effort necessary to make sure an individual completes, is no different than a probation docket. I mean, if you're a criminal court judge and you have someone on probation, part of what you do is bring them into court when they're succeeding and or when they're not complying with the conditions of probation. It's much the same thing. But remember, it is a treatment court. If the whole purpose for creating an outpatient treatment plan is to have someone adhere to treatment such that it becomes habit. For all practical purposes, I mean, we are judges, and we execute orders. Some judges know that it's more than simply signing a piece of paper. If you're in a court that handles and manages mentally ill individuals, and you're unwilling to have the passion to ensure that those individuals are treated humanely, receive the services that they're supposed to receive, and take the slight extra effort to ensure that they're following their treatment plan, why are you in the business at all?
Yeah.
I mean, why are you doing? I mean, if you are a mental health court judge, why are you a mental health court judge if you aren't willing to also want that individual to succeed in their mental health treatment?
Right.
And contrary to popular opinion, you don't become the doctor. You don't become the caseworker. You're simply making sure that the order of treatment which you've executed is being adhered to. I mean, that's what the caseworkers do. That's what the doctors do. You don't tell them what medication to take. You don't prescribe the course of treatment. You're not in the field ensuring that somebody is talking to their counselor or picking up their medications. That's what your people do. And you are the reporting authority. You are the coordinating individual that ensures that those services are in fact being done to your satisfaction. It's your court order.
Right. So you have a public mental health agency in Bexar County, right? CHCS, Center for Healthcare Services, who are essentially responsible for making sure that the treatment is all provided. Is that correct?
Correct. In our jurisdiction, we have what are called local mental health authorities. In some jurisdictions, they're called MHMRs. In the Texas scheme of things, when we execute an order, the MHMR or the LMHA is responsible for finding the suitable provider. The suitable provider in our county happens to be the Center for Healthcare Services, which also happens to be the local mental health authority. So they do one and the same. It's a somewhat complicated scenario. But nonetheless, yes, they are responsible for executing provision of these resources. And as in all things, there's always a competition for resources. And the center themselves are often at a crossroads with wanting to provide the necessary level of services for these individuals. But again, my comment is that's what we're here for. That's what they're here for.
Right.
And in Texas, under our Texas Administrative Code, court orders get the priority in under the TAC code for that type of expenditure.
So in a typical case, would that same mental health authority, CHCS in your case, be the petitioner? Would they be the ones coming into court asking you to order AOT for a certain individual?
They can. It says a person may, but as a practical matter, the district attorney is the individual who, or the hospital is the individual who begins the application. In our jurisdiction, we found that although we can do it outside the context of a hospital, it works best when they're in the hospital in an inpatient setting, and either the doctor feels that it's time to discharge the individual and they need to be on a court order so they successfully complete. They apply, the DA takes the case.
Right.
Or in Texas, I've already ordered inpatient commitment, and it's at the middle or towards the end of that commitment with some time left. We modify it to outpatient. Our statute says that the remainder of that order can be done on outpatient, and that's a simple modification. It says the judge is ordered inpatient. We hereby are asking the judge to continue that order only on an outpatient basis. We then execute the orders for the provider to provide those services.
Right.
So that's the easiest way.
So just to help people understand sort of the sequence of the process, it sounds like you're describing people basically coming out of hospitals, that this is part of their discharge planning to get them back into the community with sort of a soft landing. So the initial impetus for it is coming from the treatment team at the hospital.
From the hospital. I mean, remember that you can't be on an outpatient order in Texas unless 2 or 3 things come together. That is, you have to be mentally ill. To surmise, you have to be mentally ill, and that because of that mental illness, you've demonstrated an inability to live safely in the community.
Right.
And that because of that mental illness, you're unable to successfully comply with treatment or do treatment without benefit of the court order.
Right.
When those 3 things come together, then it's appropriate to execute an order that asks someone to follow the court's order in treatment.
Okay. So the hospital then has a standing relationship with the DA's office, and they will ask the DA's office to file a petition on this patient's behalf in your courtroom.
Right. They do the application. The DA picks up the petition.
Is there a certain ADA who handles this as a matter of course?
In our jurisdiction, our district attorney, it can be a county attorney in Texas, but our district attorney prepares and executes those motions and handles the case in court. We're fortunate in that our DA has assigned 1 or 2 DAs, assistant district attorneys, to only and exclusively do mental health. I mean, we do 4,500 cases a year.
Right.
So the docket is large enough for us to do that.
And who's representing the patient?
We, in our jurisdiction, have decided and are using public defenders. We have a public defender's office. There are 2 public defenders that handle all those cases. And I think they have a couple of part-timers that'll go out into the hospitals and visit with the patients.
Is it the same as takes place with inpatient hearings? Is it basically the same process?
It's the same public defenders.
Right.
As a matter of fact, it works best in that context. So the public defenders are going to represent this individual one way or the other. They're either going to represent them for an inpatient commitment, or going to ask that they go to outpatient. The cost, there isn't an additional cost to having a public defender represent outpatient cases. Again, we do it in the context of the hospital. They're representing them the minute they hit the hospital anyway. It's just a different outcome.
Right.
Some jurisdictions and other jurisdictions do have a rotating wheel where various attorneys are appointed to represent these cases on a monthly manner. Again, that works as well. It's a myth that because you are incorporating outpatient treatment as an option to the outcome, that it somehow increases the volume of work. It's simply a different outcome to the very same case you were already representing and having to resolve.
Sure. So the petition is filed, just to get back into the process a little bit, comes before you, you review it. I assume you see everything is in order. You're going to call a hearing date. Is that right?
Correct.
And what typically? Right. What typically takes place at the hearing? Is it an adversarial hearing where there's a real burden of proof upon the petitioner?
In Texas, once the hearing is set, the court may do one of two things, may either proceed with an inpatient commitment. An inpatient commitment requires a finding of dangerousness to self or others,
Right.
or a gravely disabled standard such that the individual is so gravely disabled they can't be out in the community.
Right. But in these cases, you're dealing with people who are already in the hospital now.
Correct.
Very often, so that's not the issue. It's
Well,
about
no, I mean, they're in the hospital initially. This is the hearing that determines whether they're going to stay in the hospital for up to 90 days.
I see. Okay.
So they're in the hospital for some reason, some crisis.
Right.
And within so many days of being in the hospital, the doctors have asked for a commitment. So they've been appointed an attorney. They're already the case is already going to happen. And the question is the outcome going to be inpatient, or is the outcome going to be inpatient or outpatient in lieu of inpatient?
I see.
It is simply outpatient is simply another outcome. It is not an additional type of hearing in our jurisdiction.
Right. Do you ever have cases? I'm curious whether you ever have situations where a person is initially ordered to inpatient, completes a term, whether it's 30, 60 days of inpatient care, and then at the point where their doctors feel that they are ready to come back into the community with some supports in place, at that point, do you ever have a petition filed for a current committed inpatient to become a committed outpatient?
Absolutely.
Okay.
That's that modification I spoke to earlier.
Gotcha. So it sounds like what you're describing then is a conversion of the order that's in place. In other words, you have a person who's under an inpatient order, you're going to modify that and turn it into an outpatient order rather than replace it with an entirely new order and a whole new court process. Is that right?
Yes. So in our jurisdiction, once I have already committed an individual to inpatient in one of these mechanisms,
yeah,
it is possible that either the person is discharged before the expiration of that court order, and that court order is modified to outpatient for the remainder of that order, right, or at the end of that inpatient order, if there isn't any time left to use,
yeah,
the doctor can petition that we do an involuntary outpatient for 90 days.
Right.
That's another option, yes.
Gotcha. And that happens sometimes.
That happens, yes.
Yeah. Okay.
So especially with the long-term patients who are truly treatment resistant. First of all, those of us who do this, at least in Texas, as often as I do here in this jurisdiction, are aware that very few people actually wind up in a hospital any longer for 90 days. The lack of resources, the shortage of beds just precludes that.
Right.
So outpatient provides a safety valve, an escape mechanism for these truly overcrowded beds. The doctors can get them to a point where, yes, it's possible they could stay in inpatient a little longer, but knowing that there's a lesser restrictive alternative to discharge, or to inpatient, other than straight discharge, they then ask us either to modify the remainder of the order or ask us for yet another order of outpatient instead of another order of inpatient. It provides that less restrictive alternative and a safety valve. And it turns out the doctors are utilizing it more and more and using the bed capacity for the truly chronic and acute individuals.
Right. Okay, let me ask you about a couple more things before I let you go. You talked a little bit about the fact that people get a nice package of services as part of this court order, that it's not just about making putting them under an obligation, but also about the system making an obligation to them. What would you say to those who may be operating in jurisdictions where resources are scarce, where there's a feeling that there's not enough to provide decent services to people who they're serving now on a voluntary basis, who think that, well, you guys in Bexar County just have things to offer that we don't, and as nice as this program sounds for you guys, there's just no way we could do anything comparable here. What would your response to that be?
Well, my response is we weren't always what we are now. Every great oak sprang forth from an acorn. And the truth is we didn't have many resources. We didn't have many opportunities. But we began with a judge and a caseworker who at the very least was responsible to ensuring that an individual made it to their doctor's appointment. And then that grew to a judge who coordinated every week to ensure that the court order was being followed. And then that grew to enough savings, enough efficiency, proof that the concept worked, to the point that we would rather spend our resources in housing, in housing these individuals rather than inpatient settings. We would rather spend our resources in counseling rather than inpatient doctors. We would rather send an ACT team member. So the answer is simply this: start as small as you can and grow. That's how we began. Just because you don't have the services now doesn't mean you won't have the services 5 to 10 years from now as we grew.
Right. It sounds like what you're saying is that use of this program has a lot to do with why you were ultimately able to provide those services, because of the savings you realized from not having to hospitalize people as much. Is that fair to say?
Sure, absolutely. In fact, I think that at some point I'll send some numbers. I'm sure you can post along with this.
Yeah.
But so roughly, we studied, for example, here recently, 70 some odd people at random on the court order. We cut their hospitalizations by 80%. So these people had been eating up somewhere in the neighborhood of 8,000 bed days a year. By the end of that, they were no longer, at the end of the court order, they were only utilizing 3,000 or so bed days a year. That's 5,000 bed days these people ordinarily took regularly every year that they were no longer taking. You multiply that by the average state hospital cost or contract cost of $400 or $450. That's a few $1 million,
right,
worth of savings. Right. It's an amazing, it's an amazing savings. And my comment for the judges and the jurisdictions that say, we don't have those resources. Well, if these people are receiving ACT services voluntarily, if they're receiving any type of services voluntarily from a provider, all the court order does is overlay a judge's supervision such that the truly treatment resistant know they have to access treatment. And in all honesty, it's a toothless tiger. We can't in Texas simply detain someone because they don't want to access treatment, but it puts them on the radar.
Right.
And even in those cases where individuals don't want to access treatment or look me in the eye and say, I don't care, you can't make me do this, they're on the radar. And we are then able to react quickly with an order of detention when they do deteriorate. And wouldn't you rather have the most difficult treatment-resistant individuals in your community on a judge's radar rather than off the radar, even if the only thing you can do is be prepared to detain them when they deteriorate? Of course you will.
Right.
There's no additional cost to that. And it's a safety, it's an immeasurable safety mechanism for a community which otherwise finds out about these cases in headlines or on tomorrow's news.
Right. And I'm glad you made that last point, because it actually leads me into the last question I wanted to bring to you, which is, this idea of the fact that you can't do what a judge normally does in a court order situation. You can't hold a person in contempt of court under the AOT law you have in Texas. You've actually got a provision, as many other states do, that explicitly says a person who violates this order shall not be held in contempt. A lot of judges look at laws like that and sort of throw up their hands and say, what is the point of putting someone on court order if I can't enforce it? And can you just talk a little bit more about how you react to that I think pretty understandable reaction?
It's an understandable reaction, but it's misguided. And I'm not meaning to insult any other jurist.
Yeah.
If that were true, then everybody would have to be sanctioned in order to be able to successfully complete a court order. And we know that's simply not the case. There are many people who complete probations, who comply with court orders without ever feeling or needing or testing the need for sanction.
Yeah, some might argue that it's the threat, their knowledge in the back of their minds that they would get in trouble for violating the order that keeps them honest.
Most of us are raised, and most of us are ill or not. We understand authority. We understand the authority figure, and we understand that we need to comply with what a judge says. And yes, there are individuals who will not comply no matter what you ask them to do, and they will, want you to use your authority. In such circumstances, the benefit to having an AOT standing order is that when they deteriorate, you're already aware of their deterioration. You already have a mechanism for monitoring that deterioration, and you can bring them into the hospital that much quicker. And even then, the cost savings is incredible. So let's assume we have a judge who says, I'm not going to do this because I can't do anything. Well, yes, you can once they deteriorate. So if I catch an individual at the onset of their deterioration, get them to the hospital under the proper legal criteria, their hospitalization is much shorter because I've addressed their need at the onset of deterioration.
Right.
Conversely, without the court order, you wouldn't see this guy for 2, 3, or 4 months or until he's tomorrow's headlines. And then his hospitalization is much, much longer because his illness has deteriorated that much further.
Right. Yeah, I think what you're getting at is that there is a consequence to violating the court order. Just because there's no punishment involved is not to say there is not a consequence or that the system doesn't have a reaction to that. And
Absolutely.
Right. So that's a very important point to reinforce. So thank you. This has been really enjoyable and hopefully edifying for our audience. If anyone listening to this has any further questions for you, I would just encourage them to please bring them to me. I'd be happy to run interference and get some more information from the judge. Please keep up the great work that you guys are doing. How many people do you have in the program now, if you haven't said already?
Yeah, our court order is set up to handle about 80 individuals in our community at any given time. It fluctuates in terms of size depending on the number of caseworkers. We just happen to have a couple of caseworkers. One's a new parent. One is on maternity leave. So we're down a couple of caseworkers. At the moment, our census is a little lower. It'll be back up next month. But we're set up for about 80 individuals.
Right. Pretty great. Thanks again.
Anytime. I hope, and I encourage judges to look at AOT and understand ultimately it's nothing more than using the services you currently have, whatever they may be, and allowing a judge to look a patient in the eye and say, get this done.
Fantastic and well said. Really appreciate your time.
Thank you.
Take care.